Hello, YouTube. I'm Vince White. I'm an employment attorney, and recently, my firm has been suing a Fortune 100 company so much that, without naming names, they assigned us our own liaison within their company. Right? They're in somebody in their in-house legal department was assigned specifically just to handle our claims. They're like, hey, you you got us too busy. We got to organize this. We're gonna put it all with this one human being, this one attorney who's going to manage all the cases you bring against us. Which I thought was delightful because it's nice to know someone's going to be on top of signing our checks and getting our clients' checks, right? That's lovely. But it can also be weird. And it's something worth talking about, right? So our industry um, has a dirty has a variety of dirty sides to it, including the fact that we're putting dollar figures to hate, right? That's super dirty. It's weird. It's kind of hateful. Um, a guy who looks like this probably shouldn't be telling a woman what her workplace sexual assault is worth. That feels wrong. Feels it's my job, and I do it because my clients need me to do it, and they need my help. But like, it's weird, right? It's a weird thing to be doing. But stepping past the obvious, we also have a couple other weird, dirty secrets. There's been a number of scandals in our industry where firms who had a large volume of cases against a defendant, an employer, sometimes take bribes or work out special volume deals with the employer where a large bulk of cases are all settled on terms agreed in advance, or where perhaps a firm accepted a rather large check or payout and then use their influence with clients to get all the clients to kind of get in line and take lesser amounts, right? I'm not going to name names. We don't have time to name names. Frankly, this has happened repeatedly in our industry. But it's something that goes on, and it's something that creates havoc for decades after it happens, right? Because forevermore, there's going to be clients who've been pushed around, treated badly, treated horribly by their employer, who are then going to say, "No, I think you're screwing me too." I'm not. I'm not. Most attorneys are not in our field, but without a doubt, there are bad attorneys in our field, and that leads to this paranoia, somewhat legitimate paranoia, right? Like if you're in a situation where you don't fully understand the rules, right? The courts, you're not a lawyer. Even if you're a lawyer, you're probably not a litigation attorney. So everything is kind of weird and strange to you, and nothing really in the process of litigation makes all that much sense unless you live litigation day in and day out, right? Everything in this field feels counterintuitive, and often people who come to it for the first time say, "I, there's no way you guys do this way. This is insane. You're all insane people. There's no way this is how things are done." It is in fact how things are done. It's just that the way litigation happens in arbitration and mediation, the way all these things happen, doesn't make sense unless you do it every day, unless you live with the conflict of this every single day, right? But that paired that concern, like, this doesn't make any sense, paired with the concept of like, why are you the one telling me what my case is worth when you didn't experience the things that I experienced? How can you know what I went through, right? And then let's add the third element. I'm out of hands here, but the third element, right? Of I know firms have had fixing scandals before. I know firms have been bribed before. You're selling me out, right? You put the three of those together. If you don't really trust your attorney, well, it's going to be hard to start taking advice from this attorney, right? Um, so I say this only because volume volume practice, you help a lot of people. But there's also this tension of like horse trading, right? The attorney on the other side says, listen, I paid you out big in the last 6. I need a win. This case is not as good. I need you to take a lower amount on this. And you as the attorney have to be like, no, I can't do that. Every case is distinct. Every case is its own value. We fight every case as its own situation. And that's different in class. Class actions are a separate situation, and we can talk about that, but like not today, because we don't have the 17 hours to discuss class actions and the morality of what attorneys do in class actions, the legality, and the checks and balances are just, okay, let's take all of that. It's gone. We can't deal with it today. These are just in individual cases where you have many, many individual cases against a single employer. There becomes this relationship with the opposing counsel, and you can't let it grow. You can't let it. Right? As counsel, you have to say, every case is individual. It's unique. It will be fought as its own entity. The end, there's no tradesies. There's no helping hands. There's no, we'll pay you big on the next one. No. Every case is distinct. It has to be that way. I don't know. I mean, I guess, I don't know who this is meant to help. Attorneys handling high volumes of cases, or clients dealing with attorneys who they know have a high volume of cases with a particular employer. I guess both, maybe. I hope it helps someone. That's what I hope.